Legal and Privacy Brief for April 7, 2026. Google settles $135 million Android data transfer class action, while Nike faces litigation over a January 2026 data breach that exposed customer payment data. Tech companies pledge to continue CSAM scanning in Europe despite the expiration of legal protections, and Congress reintroduces legislation to grant copyright protection to building codes and safety standards incorporated into law. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief April 7, 2026. Next section, Enforcement Actions. FBI reports $17.6 billion in cyber fraud losses for 2025. The FBI's Internet Crime Complaint Center reported that cyber-enabled fraud accounted for 85% of all losses in 2025, totaling $17.6 billion across over 1 million complaints. Investment fraud led all categories at $8.6 billion, followed by business email compromise scams at $3 billion and tech support fraud at $2.1 billion. Ransomware complaints increased to 3,611 incidents with over $32 million in reported losses, up from 3,156 complaints and $12 million in 2024. The FBI is currently investigating over 200 ransomware variants and identified 63 new variants last year. 14 of the 16 U.S. critical infrastructure sectors were victims of ransomware attacks in 2025. Compliance action. Review incident response procedures for ransomware and BEC scams. Organizations in critical infrastructure sectors should verify offline backups and test restoration procedures given the documented increase in ransomware targeting. Sources: The Record. German authorities identify 2 R-Evil ransomware suspects. Germany's Federal Criminal Police Office identified 2 suspects linked to the R-Evil and Gan Krab ransomware gangs. Mikhail S.H. Chukin, a 31-year-old Russian national using the alias Unkin, and Anatoly Kravchuk, a 43-year-old Ukraine-born Russian citizen, are wanted internationally for approximately 24 ransomware attacks that generated nearly $2.3 million in extorted payments and caused over $40 million in economic damage. Both suspects are believed to be in Russia. R-Evil operated under a ransomware-as-a-service model and targeted high-profile victims including Lady Gaga's law firm, President Trump, and software provider Cassia before being dismantled in 2021. Sources: The Record. First stalkerware manufacturer convicted since 2014 receives no jail time. Brian Fleming, founder of PC Tattletale, was sentenced to a $5,000 fine and no prison time beyond 1 day, already served after pleading guilty in January to 1 count of manufacturing, distributing, possessing and advertising wire, oral or electronic communication, intercepting devices. Fleming's Michigan-based stalkerware company sold surveillance products marketed for spying on spouses and others without consent. The prosecution resulted from a Homeland Security investigations probe that began in June 2021 and covered more than 100 stalkerware companies. Fleming promoted the product on YouTube, showing how users could install it on Android phones where they won't be able to see it and view a movie of everything they've done. Compliance action. Organizations should review employee monitoring software to ensure compliance with state wiretapping laws and Federal Computer Fraud and Abuse Act provisions. Monitoring software must provide notice and obtain consent. Sources: The Record. Next section, Litigation Updates. $135 million Google Android data transfer settlement, case No. 5 to 20 CV 7956 VKD. Google agreed to a $135 million class action settlement to resolve claims that Android devices transferred information to Google without user permission over cellular data networks. The lawsuit Taylor et al. v. Google LLC in the U.S. District Court for the Northern District of California alleges that Google's Android operating system caused devices to transfer information in the background even when idle, using cellular data instead of Wi-Fi connections. The settlement benefits approximately 100 million class members who used Android devices with cellular data plans to access the internet since November 12, 2017. Each class member is expected to receive an equal payment from the settlement fund, though exact amounts are not yet available. Google also agreed to update its Google Play Terms of Service, Help Center documentation, and device setup screens to disclose the conduct and request user consent. The deadline for exclusion and objection is May 29, 2026, and the final approval hearing is scheduled for June 23, 2026. Compliance action. No claim form required. Class members automatically receive settlement benefits unless they opt out by May 29, 2026. Those preferring direct deposit must select their payment method on the settlement website. Sources: top class actions. Nike data breach class action filed in Oregon, case No. 6-26 CV 500 and 64 AP. Plaintiff Maria Gomez filed a class action lawsuit against Nike in Oregon federal court, alleging the company failed to safeguard customer personally identifiable information during a January 2026 data breach. The lawsuit claims Nike's network was infiltrated by cybercriminals who accessed names, email addresses, billing addresses, phone numbers, transaction information, and payment card details. Nike allegedly discovered the breach on January 21, 2026, but did not begin notifying victims until February 25, 2026, more than a month later. Media reports indicated a ransomware group published 1.4 terabytes of Nike data on its website. The complaint alleges negligence, breach of implied contract, and unjust enrichment, claiming customers are now at imminent risk of identity theft and fraud. Compliance action: organizations experiencing data breaches should review state breach notification laws. Most states require notification within 60 days of discovery. Delays beyond these statutory windows create additional liability exposure. Sources: top class actions. State Farm Total Loss Claims Settlement receives preliminary approval, case No. 4-21 CV 1161. A federal judge granted preliminary approval to a $15.58 million class action settlement, resolving claims State Farm underpaid policyholders for total loss vehicle claims in Arkansas. Plaintiff Rose Chadwick filed the lawsuit in November 2021, alleging State Farm systematically underpaid insureds by basing compensation on Auditex valuation reports that applied improper typical negotiation adjustments. The settlement covers persons who made first-party claims on policies issued to Arkansas residents between November 29, 2016 and October 18, 2021, where vehicles were declared total losses with payouts based on Auditex reports applying typical negotiation adjustments. Class members are eligible for payments of 68% of estimated TNA amounts, with an average recovery of approximately $489 per claim. The deadline to opt out is June 25, 2026. The deadline to object is June 15, 2026, and the final approval hearing is scheduled for July 15, 2026. Sources: top class actions. Federal Circuit affirms approval of Class Representative Incentive Awards in National Veterans Legal Services Program v. United States. The Federal Circuit joined the clear majority of circuit courts in holding that district courts are permitted to approve incentive awards for class representatives. The case involved a class action settlement regarding overcharging of fees for the judiciary's PACER system. The district court approved $10,000 incentive awards to each of 3 nonprofit organizations that served as class representatives. The Federal Circuit rejected objections to the awards, relying on the history of Rule 23 and rejecting comparisons of incentive awards to salaries or bounties. The court found that incentive awards permissibly recognize the meaningful burden, including facing reputational risks and expending time and effort, that class representatives undertake. The decision deepens the circuit split with the 11th Circuit, which stands alone in finding incentive awards per se unlawful since its 2022 decision in Johnson v. NPAS Solutions, LLC. Sources: inside class actions. Supreme Court sends Steve Bannon case back to lower court. The Supreme Court sent the case of Stephen Bannon, convicted of contempt of Congress for refusing to comply with a House January 6 committee subpoena, back to the lower court, where the Department of Justice filed a motion to dismiss his indictment. Bannon was convicted of violating a federal law that makes it a crime to willfully fail to respond to a congressional subpoena and served 4 months in prison. The U.S. Court of Appeals for the D.C. Circuit upheld his sentence and rejected his argument that his failure to comply was not willful because he acted on his attorney's advice. The Trump administration urged the Supreme Court to invalidate the D.C. Circuit's ruling and remand the case so the district court could grant the government's motion to dismiss. Sources: Scotto S. blog. Next section: regulatory guidance. Microsoft reports Medusa ransomware exploiting 0 days. Within 24 hours, Microsoft published research showing that the Medusa ransomware operation is increasingly exploiting new vulnerabilities days before public disclosure, with multiple cases where the group moves from initial access to data exfiltration and ransomware deployment within 24 hours. Microsoft cited 2 recent examples: CVE 2026-23760 in Smarter Mail and CVE 2025-10035 in Go Anywhere Managed File Transfer, which Medusa actors exploited 1 week before public disclosure. CISA the Cybersecurity and Infrastructure Security Agency, previously confirmed both CVEs have been used in ransomware attacks. The group targets vulnerable web-facing systems during the window between vulnerability disclosure and widespread patch adoption. Recent victims include healthcare organizations, education institutions, professional services firms, and finance sector entities in Australia, the United Kingdom, and the United States, including Mississippi's largest hospital and Passaic County, New Jersey. Compliance action. Organizations must maintain current inventories of web-facing assets and establish procedures to apply security patches within 24-48 hours of disclosure for Internet-exposed systems. The traditional 30-day patch window is inadequate for perimeter systems given threat actor exploitation timelines. Sources: The Record. Next section, privacy developments. Tech companies vow to continue CSAM scanning despite expiration of EU legal protections. A European Union law allowing tech companies to scan communications for child sexual abuse materials expired on April 5, 2026. But Microsoft, Google, Meta, and Snapchat released a statement pledging to continue voluntary scanning despite potential legal risk. European Commission spokesperson Guillaume Mercier cautioned that, without a legal basis, companies are no longer allowed to proactively detect child sexual abuse in private communications. The decision to let the law expire was contested, with critics arguing the scanning allowed indiscriminate surveillance and violated privacy rights, while law enforcement officials and several European commissioners supported maintaining legal protections for the scans. Lawmakers have been negotiating to find a permanent solution since November 2023, but have been unable to agree on terms. Compliance action. Organizations operating in the EU should monitor developments in the CSAM scanning negotiations. Continuing to scan communications without explicit legal authorization creates exposure to privacy enforcement actions under GDPR, the General Data Protection Regulation, and the E-Privacy Directive. Sources: The Record. Hong Kong police granted authority to demand encryption keys. Hong Kong authorities changed the rules governing enforcement of the national security law on March 23, 2026. Granting police the authority to require individuals to provide passwords or other assistance to access personal electronic devices, including cell phones and laptops. According to a U.S. Consulate General Security alert dated March 26, refusal to comply is now a criminal offense. Authorities also have expanded powers to seize and retain personal electronic devices as evidence if they claim the devices are linked to national security offenses. The requirements apply to individuals transiting through Hong Kong's airport. Compliance action. Organizations with employees traveling to or through Hong Kong should establish procedures for using travel-specific devices with minimal sensitive data. Consider policies prohibiting transport of devices containing trade secrets, customer data, or privileged communications through Hong Kong. Sources: Schneier on security. New Mexico Meta ruling creates precedent for design liability and encryption. A New Mexico court ruling against Meta has created implications for end-to-end encryption and security features after the state attorney general used Meta's 2023 decision to add end-to-end encryption to Facebook Messenger as evidence against the company. The state argued that predators used Messenger to groom minors and exchange child sexual abuse material, and that encryption made it harder for law enforcement to access evidence of crimes. The state is now seeking court-mandated changes, including protecting minors from encrypted communications that shield bad actors. The ruling establishes a design liability framework where product improvements that protect the majority of users can be held against companies if a small fraction of bad actors exploit them. Compliance action. Organizations should document internal safety and privacy deliberations carefully. The New Mexico case demonstrates that good faith risk assessments and internal safety discussions can become plaintiffs' exhibits presented as proof of knowledge and willful disregard. Legal counsel should review documentation retention policies for product development and security implementation discussions. Sources: Schneier on security. Next section, policy changes. Congress reintroduces Pro-Codes Act to grant copyright protection to incorporated standards. Senators Coons, Cornyn, Hierno, and Tillis reintroduced the Pro-Codes Act, legislation that would grant copyright protection to standards that have been incorporated by reference into law. The bill would make building codes, fire safety codes, electrical codes, and accessibility guidelines the copyrighted property of private standards development organizations that wrote them, despite multiple federal courts, including the Supreme Court, the Fifth Circuit, the D.C. Circuit, and the First Circuit, ruling that no one can own the law. The bill includes a provision requiring incorporated standards be made publicly accessible online, but specifies this access must be provided in a manner that does not substantially disrupt the ability of those organizations to earn revenue. Organizations providing free public access to incorporated standards, including public, resource, org, and up codes, would face copyright liability under the bill. Compliance action. Organizations should monitor the Pro Codes Act legislative progress. If enacted, the law would restrict access to building codes, fire safety codes, and electrical standards that govern code compliance, potentially requiring paid subscriptions to access laws that violations can carry civil or criminal penalties. Sources: TechDirt. UK advances social media ban, enabling Secretary of State to restrict internet access for under 18. The UK House of Commons proposed an amendment to the Children's Wellbeing and Schools Bill, enabling the Secretary of State to require providers to prevent access by children under age 18 to specified internet services or features, replacing a House of Lords amendment that would have banned under 16s from all regulated user-to-user services. The Commons proposal transfers power from Parliament and Ofcom to the Secretary of State for Science, Innovation and Technology, who can restrict internet access for young people, determine harmful content, limit VPN use for under 18s, restrict access to addictive features, and change the age of digital consent without demonstrating specific harms. The process contains no accountability mechanisms and does not require ministers to assess online services according to established risk frameworks. Sources: TechDirt. Next section: Compliance Takeaways. Patch web-facing systems within 24-48 hours of vulnerability disclosure. Microsoft's Medusa research demonstrates ransomware groups are exploiting vulnerabilities within 1 week of disclosure and completing full attack chains within 24 hours of initial access. The traditional 30-day patch window is inadequate for internet-exposed assets. Review data breach notification procedures to ensure compliance with state statutory timelines. Nike's 1-month delay between breach discovery and victim notification creates additional liability exposure. Most states require notification within 30-60 days of discovery. Establish travel security policies for employees transiting Hong Kong. Hong Kong authorities can now demand encryption keys and seize devices from individuals transiting the airport. Organizations should provide travel-specific devices with minimal sensitive data for employees traveling to or through Hong Kong. Monitor the Pro Codes Act legislative progress and budget for potential compliance costs. If enacted, the legislation would restrict free access to building codes, fire safety codes, and electrical standards incorporated into law, potentially requiring paid subscriptions to access compliance requirements. Document product security and privacy decisions carefully. The New Mexico Meta ruling demonstrates that internal risk assessments and safety deliberations can become evidence in design liability cases. Legal counsel should review documentation retention policies for security implementation discussions to balance transparency with litigation exposure. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.